Hi, everyone. Thank you for joining us today for Constangy's webinar, Marijuana in the Workplace, Guiding Employers Through the Cannabis Maze. A couple of housekeeping items before we get started. Today's webinar is approved for SHRM and HRCI credit. We will provide these codes to you at the end of the presentation, so please stick around in order to get those. If you have questions throughout the presentation, please submit them through the chat function. You can access the chat through the toolbar located at the bottom of your screen. Our presenters will leave some time at the end to answer your questions. Also type in the chat where you're joining us from today. Lastly, we will be providing a copy of the PowerPoint used during today's webinar and a recording of the presentation. These materials will be sent to you once the recording has been uploaded by tomorrow afternoon. Today, members of our Cannabis and Employee Substance Abuse Practice Group will be leading us through this presentation. We have a team of professionals with extensive experience guiding employers through the cannabis maze and with substance abuse issues arising in the workplace. Members of our group have experience leading full-service cannabis practice groups and therefore are able to offer clients a broader legal perspective on industry trends. We offer comprehensive coverage throughout the United States, staying up to date with the most recent laws and regulations on both the state and federal level. I'm now going to turn it over to Kia.
Thank you, Victoria. Good afternoon, everyone. Thank you for joining us. I'm going to be joined today by Ashley Orler and Nestor Barrero. These are two of my partners in Chicago and California, Los Angeles. And as you'll see today, we're going to take a broad overview and talk a little bit about what's going on with cannabis laws across the country as they relate to the workplace. I'm going to start out today, and I'm going to talk a little bit about, the general landscape, where we are as of today, April 20th, 2023 on the federal side, and then what it also looks like across the country in the states. Because as you may already know, this is very much state law driven. So we'll talk about that a little bit. And then I'm going to talk in a little more detail about what's happening in New Jersey currently. I'm going to be doing that because New Jersey is a little bit of a test case at the moment, as you'll see. And then I'm going to turn that over to Nestor and Ashley, and they're going to offer us some insights, not only in other areas of the country. Nestor's going to cover what's happening in California, and as you'll see, there's some new things that are happening, and starting January 1st, 2024, there's going to be plenty to talk about in California. And then Ashley is also going to cover some things that have been happening in the middle of the country in Illinois. And also she's going to discuss, some takeaways for employers and what we should be thinking about and what we want to be doing to address these issues, which are quite frankly difficult, especially if you're operating in multiple states across the country. So with that, let's get into it. So here with this slide, I'm giving you guys just an overview of what's happening right now. Medical cannabis is currently in 38 states, including District of Columbia and several US territories. Every time I look at that number, I still say, wow, 10, 15 years ago, it was much less. So we're really getting up there. It's more than a majority at this point. And then I also, the important thing for us today is that 19 of those, out of those 38 states, 19 of those, in their statute, in their medical marijuana statute, they explicitly contain some form of employment protections for medical cannabis users. And so that is relatively new. And those are things that we are going to talk about in a few minutes. And in fact, when I talk a little more about New Jersey, I'm going to also, provide that as a little bit of a template. Every state is a little bit different in how they formulate their statutes, but there are some common things that when we look at New Jersey, we can talk about, what is borrowed from other states and what other states maybe are borrowing from New Jersey. We also have recreational cannabis. Sometimes that is referred to as adult use cannabis. And that is in 21 states at this point, including DC. Again, huge number. That has gone up skyrocketed exponentially since around 2015. And it seems like every year we have new states that are joining the adult use ranks. I've listed those states there for you, but importantly, there's a handful of them, including New Jersey, New York, Nevada, Maine, Rhode Island, where they have employment protections for off-duty use of recreational cannabis. And that is typically the most difficult situations to deal with. And when we talk about drug testing in a little bit, I'm going to cover some of the difficulties with that, and so is Ashley at the end of our presentation today. So backing up from the state law picture, I just want to touch for a few minutes here on what's happening on the federal side. So cannabis is still illegal under federal law. It's still a Schedule I drug under the Controlled Substances Act. That means it's treated the same as other, quote unquote, hard drugs like heroin and LSD and ecstasy. Basically, to be on Schedule I, there's two criteria. One is that it has known medicinal value, and two is that it has a high potential for abuse. So that first part, no known medicinal value, that doesn't quite jive with this first slide, right? 38 states have said there's medical cannabis. And if you go to each one of those 38 states and you go to their statute, there will be legislative findings in there that talk about, the medical benefits of cannabis. So that's been a bit of a head scratcher. And so, that's led to discussions over the years as to whether or not cannabis is going to be rescheduled or maybe even descheduled. So, and we'll get to that in about a minute. But I like to start, when we talk on the federal side, really things started to change much more rapidly in around 2018. And that was a year where the FDA approved a childhood epilepsy drug called cannabinol, I always get the name wrong, Cannabinol-X. And so that was a drug that was derived specifically from cannabis. It's not synthetic, it's from the plant. And so that was the first time we had a government agency, a federal government agency saying, hey, this has a medical value. And in response to that, a couple months after that approval, the DEA went ahead and rescheduled that drug to Schedule V. So they kind of punted. They didn't address cannabis as a whole, and they didn't admit that cannabis has some medicinal value. What they did is they took that specific drug and they just moved it down to Schedule V. A couple other things that happened in 2018 that are worthy of mention for a second. We had the Hemp Farming Act of 2018, which passed in November of that year, which legalized industrial hemp. And so, products like CBD, which are, all over the place now, and you can buy them off of Amazon or in your local bodega. That is industrial hemp, and we'll talk a little more about that in a few minutes. But that was 2018, and then over the next couple of years, you actually had several forms of legislation, progressing in various forms through Congress. So. The MORE Act is one that gets a lot of publicity, and that's been kicking around for a couple of years. But the only point I want to make here is that, again, 10 years ago, 15 years ago, none of these legislations were even making it out of a committee, let alone getting onto the floor and actually, being voted on. So, while obviously Congress has the House of Representatives and the Senate have not both passed any type of legalization act yet. Again, they're still getting put forward, and there's still some moderate hope that could happen among the cannabis community. So, and then also on this slide, I put in, some states that have recently come forward. Most of the states that have considered adult use cannabis in the last couple of years that have put it on the ballot, they've passed. Although I will note that last year, I believe it was Arkansas, they rejected it. So there are some voters, usually that occurs in the middle of the country, where we've started to see, you know, they're not just passing automatically. Some of these votes are now kind of going the other way. In October of last year, President Biden made a pretty significant announcement, and he basically asked the Secretaries of Health and Human Services and the Attorney General's office to look at potentially changing the approach on cannabis, whether that means deschedule or reschedule. We don't quite know yet. The Health and Human Services director, I believe it was a month or two ago, when he was asked, you know, what the progress was and where was this going, again, didn't tip his hand, but he made an interesting comment and said, you know, we are going to take into account the public and, you know, the viewpoint of the public here, which is, and I think the comparison he made was the public thinks a lot differently about cannabis than it did in 1991. So that to me indicates that there may be some changes coming up. And then I believe Merrick Garland was interviewed a couple weeks ago, and you know, and he said, he again didn't tip his hand, but said there could be some changes coming. So we'll see what happens. And of course, if cannabis moves off of Schedule 1, that's going to open the door to many different things here, and particularly on the employment side, it could change things, you know, pretty rapidly. But until then, we still have basically a hodgepodge of state legislation. So if you are a, you know, again, an employer that operates in several different states, you basically have to take an approach where you're looking at each state and looking at the cannabis laws in each state and trying to figure out if there's employment protections there. And then you have to adjust your policy accordingly. I want to talk about industrial hemp for a minute or two here. As I mentioned a second ago, in 2018, we had a change in the law where industrial hemp became legal. So what is industrial hemp? What is CBD? How does it differ from cannabis or medical cannabis, as we refer to it? So, you know, the cannabis plant has over 100 cannabinoids. That's the chemical compound that's in this plant. And, you know, THC is the chemical compound, that is the cannabinoid that is responsible for getting you high, that has the psychoactive effects. There's another cannabinoid called CBD that is non-psychoactive, and that doesn't get you high. So the Hemp Farming Act of 2018 basically draws a line in the sand, and they say that any product that contains 0.3% THC or less by dry weight volume, that is industrial hemp. And anything above that is not industrial hemp. And so for a frame of reference here, as this slide is showing, typically, you know, medical marijuana or adult use marijuana that you could go into a store right now, and for example, in a state like New Jersey that has both medical and recreational, the product that a consumer would be buying there contains about 15 to 20% THC. So it's much more. But the point here is that there still is a very, very small amount of THC in hemp, in legal hemp. And so that means that, you know, can you test positive for taking CBD? How would that work? Well, the answer is it would be exceedingly rare for somebody who just uses CBD to test positive on a drug test for for THC, but theoretically it could be possible, and that has to do with the way that hemp and cannabis are metabolized in our bodies. And again, this is not I'm not a scientist, but to do my job, I have to understand a little bit about the chemistry here. So when you ingest cannabis, it gets metabolized by your body. And there's basically two, when you first take it, depending upon how you take it, if you take it edibly, it'll go into your body and it enters through your liver and it gets digested that way. If you smoke it, it's going to go directly into your bloodstream much quicker. But either way, your body is going to synthesize this, break it down into THC into your bloodstream, which is going to produce that high effect. And then there's going to be an inactive metabolite of the cannabis that actually binds to your fat cells. Okay. And that's why when you take a urinalysis or you go take a drug test and you do it through a p-test, what that test typically is showing is that inactive metabolite. And that's the one that binds to your fat cells. And so depending upon your body chemistry, your genetics, your weight, how much you use the product, that's going to take, could take several days. It could take several weeks for that carboxy, that metabolite to exit your body. And so when you take a p-test, this slide will show you, it could be, this says up to 7 days, but it could even be 30 days for heavier users. That urinalysis test is going to test positive for THC many days after you've ingested it. Other drugs that are on Schedule 1, for example, like cocaine or methamphetamine, those are passing through your bloodstream pretty quickly. As this slide shows, meth could be 1 to 3 days, for example. Cocaine could be 12 hours. Alcohol, which probably most people on this call have more experience with, generally, right? You kind of know if you drink a beer or 2 beers, you kind of know your own body. Maybe it takes you 2 hours to kind of process that beer, so that you're not drunk or you're not buzzed anymore. So again, I like this slide so much because it shows you how different marijuana is. And as we're going to talk about a little more kind of on the back end of our presentation today, and Ashley's going to talk about this a little bit, and the title of this slide, why are observations so important? Well, what's going on here is that when you're sending an employee for a drug test, if the idea is to try to figure out whether that employee is high or whether they're impaired while they're at work, the drug test isn't really going to conclusively establish that. All that's going to tell you is that, yes, they probably did take marijuana or cannabis, but it could have been over the weekend. It could have been at a concert, off duty, off work, not on work time. So with that said, I want to now take a few minutes and get into New Jersey. And as I said in the beginning, that's for 2 reasons. Number one is New Jersey has a fairly unique statute right now, and it's essentially just taken effect in the last year or 2. So we're starting to see how this is going to play itself out. But also it's a good opportunity to kind of look at New Jersey's law. And, some of the other statutes across the country have similar protections. So that way we can kind of talk about what a typical statute that has employment protections might look like. So first, I'm going to quickly talk about Jake Honig, which is the medical marijuana statute in New Jersey. That has an anti-discrimination provision in it. And it has for several years. First of all, it says you can't discriminate against somebody solely because they are basically a card holder, medical marijuana card holder. But it does allow employers to maintain a drug-free workplace policy, and it does allow employers to discipline or fire employees because they either possessed it or they used medical cannabis during work hours. So again, you can't discriminate against them solely because they're a card holder. It's kind of like a status discrimination, right? Your status as a medical card holder, we can't take adverse employment action just because of that. But if you come to work high, that's a no-no, and we could discipline you for that, right? So this is not about allowing a medical marijuana user to go take a gummy, on their lunch break. They can't do that. The statute does not protect that. And this is an opportunity for us now to pause for a second. Every medical marijuana statute across the country that has a similar anti-discrimination provision, all of them have that distinction. There is no law in the country that allows anybody who has a medical marijuana card to show up to work high, okay? That they all have that carve out, okay? Some of them also have carve-outs for violation of federal law. So what that means is that it'll say you can't discriminate except if not discriminating would cause the employer to violate federal law or risk federal funding or violate a federal contract. Think about maybe defense contractors, right? You're a defense contractor for the government, and under that defense contract, you have very stringent drug testing and provisions in there, right? So there'll be a carve out from that, and that's pretty typical. Most statutes would have that. Some of them have safety sensitive carve outs. New Jersey doesn't, but so not every state does. Some states do. And again, under the medical marijuana in New Jersey, it actually contains, some procedural things, like you have to give written notice of a positive drug test. You have to give them 3 days to come back with an explanation. And as part of the explanation, they can show you the card. And once they show you the card, basically, I'm telling my clients, you're not going to fire that person, right? They've substantiated that they're a card holder, and that's why they tested positive for that drug test. Let's talk quickly about PREMA, which is New Jersey's adult use or recreational statute. This has been in effect since 2021. The employment protections have been in effect since August of 2021. And so basically what New Jersey's adult use statute says is that you can't take any adverse action against an employee or an applicant because they use cannabis in accordance with the law. That's one part of it. And let me just stop there by saying, by the way, adult use means adult, 21 and older, right? So this statute doesn't protect a 20-year-old who uses, recreational cannabis, again, not medical cannabis, but recreational cannabis. So if you have a 20-year-old that uses cannabis, and for example, they test positive for cannabis and they're 20, you can fire them, right? If they're 21 or if they're older, the statute says not only can you not discriminate against them because they do or don't use cannabis legally, but you also can't take adverse action against an employee solely because they test positive for THC metabolites. That is the part that I hearken back to a few minutes ago when I talked about drug tests. The purpose of this part of the law is because the legislature is recognizing that a drug test doesn't indicate that that person is high at work. It just doesn't. It indicates that they used cannabis, sometime in the last day or up to 30 days. But because, again, it's legal to use cannabis in New Jersey, the legislature says we're not going to punish employees for that, and we're not going to allow employers to basically just use the results of a drug test, solely use the results of the drug test to fire somebody. Again, there's carve-outs under the adult use statute in New Jersey. Of course, you can still have your policies. This, again, does not mean that you have to let people come to work high. Doesn't mean that you have to let them possess it on the premises. Again, there's some government contractor carve-outs. Like I said before, this is pretty standard with these types of laws across the country, but not every state law contains these types of carve-outs, and there is no safety sensitive carve-out in New Jersey. New Jersey statute also specifically talks about drug testing, and it says that you can drug test employees for the reasons that I've listed here on the slide, but they're basically the same reasons why you would normally drug test anybody. Reasonable suspicion, post-accident testing, you can do random as long as it's in accordance with New Jersey common law, and you can do pre-employment. But the catch here is, in New Jersey at least, the way I explain this and when I do training for my clients is it's drug test plus. You can't just use the drug test, okay? You have to always pair that with something else. And what that something else is typically is observations. As Ashley's going to talk about at the end of our program, this is why statutes like New Jersey's statute, any statute that is similar to New Jersey's, and again, California, as Nestor is going to talk about in a few minutes, California is one of those when it takes effect. That California also says, hey, we don't like to just use that drug test result. You got to have something else. So this is a big red flag. You should be aware of this. and understand that you can no longer just send people for a drug test and then fire them when they're positive. You have to make sure that you're following the statute. And then one other thing here quickly that I want to mention in New Jersey, in case you operate in New Jersey or you have employees in New Jersey, there's also something called a WIRE, a workplace impairment recognition expert in the statute. Now, what that is basically the New Jersey legislature, and in my experience, this is actually unique. No other state has this yet. What they're saying is that when you do a drug test, you have to accompany the drug test with a physical evaluation. So you can't just send somebody for a drug test. You have to do a physical evaluation of the person, and then you can drug test them. And the physical evaluation has to be done by this WIRE. And the WIRE is somebody who's been certified to detect impairment in the workplace. And so the New Jersey Cannabis Regulatory Commission is supposed to come up with a certification program so that New Jersey employers can send somebody to get certified, or they can use a third-party service to do this. And they have this WIRE certification, and that person's going to be able to basically opine as to whether or not somebody's impaired or not. Now, you know, I'm based in New Jersey, and all of us employment lawyers here in New Jersey, we kind of look at that as like, wow, that is, it's a bit of a bridge too far. And certainly in my view, as a management attorney, I think this is putting a lot of unfair requirements on employers in New Jersey to have to do this. But it is what it is. But at the moment, you don't have to do this yet in New Jersey. The Cannabis Regulatory Commission has said they're smart enough to know that they don't have all the answers here yet. So they put a pause on the physical evaluation requirement until they can figure out what they're going to do with this certification program. So in the meantime, they issued some guidance. Basically, the guidance in New Jersey says, until we come up with a certification program, you should do two things, employers. Number one, you should designate somebody that's going to make these observations before you send somebody for a drug test. And you should train them, at least nominally, you know, and figure out how to observe. And again, Ashley's going to talk about this at the end. And two, you should use some type of report or some type of document to document objectively, you know, document these observations. And the New Jersey Cannabis Regulatory Commission gave us a form that they used. I think they stole it from Colorado, to be quite honest with you, but there's a form to use. So you got to have some type of standard operating procedure. You got to appoint somebody, you got to use some type of form, you should do some training. And I think that that's good advice for everybody. So with that, I'm going to turn this over to Nestor. He's going to talk to you about a recent development in California, which is actually pretty similar to what I just described is going on in New Jersey. And I would look to 2023 as a year where we're going to have New Jersey and California, figuring this out and coming up with some approaches. And we'll figure out if there's going to be similar approaches or maybe they're going to be divergent. So Nestor, take it away.
Thank you. I'm Nestor Barrero. I'm a partner at Constangy in our California office. I work mostly in Los Angeles and Southern California with some clients up in the Bay Area. When we were putting together the presentation, I talked to Kaya and Ashley about this, and we kind of came to the conclusion that New Jersey and California are kind of the two, outliers in a sense, and outliers that are kind of going in the direction that many states may follow. We've seen this happen before. For example, paid sick leave started mostly in California, and now it's spread across the country. So, and New Jersey is very active in pro-employee type legislation. So for those of you in other parts of the country, especially blue states, you're not seeing these approaches yet. It's very likely that you will see something like this, something like what's going on in California, or New Jersey or Colorado for that matter, coming to your state in some variation, and just be aware of that. Quick background about what happened in California. Back in 1996, we're almost now going on 2 decades. Cannabis was made legal in California for so-called compassionate use for medicinal. Now, with a statute that went into effect a couple of years ago, recreational use is now permissible in California. And they're just like New Jersey, they set up a whole bureaucracy and agency to take charge of so-called cannabis control in California. And the idea, which I think is the right one, is to regulate it safely, to keep cannabis away from children, to regulate quality, et cetera. So in California, at least, we have a department that tries to regulate in this area, regulate the producers and the retail shops that work in the cannabis industry. Let's go to the next slide. So in California, you can buy cannabis if you're 18 or older with the recommendation of a doctor, so for so-called medicinal use, or if you're 21 or older, just like alcohol, you can legally purchase and use cannabis. There may be stricter laws about cannabis than the state in certain cities and counties. Again, you may want to determine what the rules specifically might be in the city or county that you have, but they usually revolve around things like where the cannabis shops can be, what they can sell, not so much about any kind of workplace issues or workplace restrictions. If you're a medicinal user, you can have higher possession limits, you can grow plants, you can have more cannabis. Next slide. But depending on kind of the context in which you're using cannabis or a cannabis product, you can be limited. So property owners can ban the use of cannabis on privately owned property. Hotels can restrict it. You can't, because of the federal law that Kia mentioned before, you can't possess it on federal lands like national park. If you're in, Yosemite National Park or some of the other parks we have out here, it can still be illegal to possess it, to use it in those parks. Whether that's enforced very much is another question. My guess is probably no. But keep that in mind, that if you were to get arrested on a kind of a DUI, for example, or some other infraction based that is related to use of cannabis, you could have some problems if you happen to be on federal land. And we advise clients who and employers to remind their employees that you can't take it across state lines. So if you're driving across the country to Arizona, for example, or flying across the country, having cannabis in your possession can be a problem. And you're not going to necessarily be protected because the state that you're coming from or the state that you're going to permits it. Next one. You can't use cannabis in public places like restaurants or bars. So this is not a license to be high in public. You can't smoke cannabis where it's illegal to smoke tobacco, or within 1,000 feet of a school, a daycare center, or youth center while kids are present. So any of you who operate those types of facilities, private and public schools, daycare centers, youth centers while kids are present, can, on top of having restrictions on being impaired at work, et cetera, you also get the benefit of these restrictions of anyone, whether it's your teachers, your parents, vendors, anybody smoking cannabis within 1,000 feet of your particular center in California. Not a lot of case law in California on this issue, but the one kind of big case out in California, which now goes back to 2008, that's 15 years ago, which kind of in the timeline of developments is a long time ago in California in terms of what's happened since that point. But back when the first medicinal California Compassionate Use Act was enacted, the California Supreme Court back in 2008 considered the case of an employee who was taking marijuana for medicinal purposes for a back injury, tested positive, got fired, and the employee sued saying, hey, I'm protected by this disability discrimination law, which effectively says that if I need this under the Compassionate Use Act of 1996, it's prescribed by a doctor, I shouldn't be subject to sanctions from my employer. The case got litigated. It went up to the California Supreme Court, and the court said, which I think was kind of the right conclusion, yes, doctors can't get prosecuted. You can't be prosecuted at least under state law, but it doesn't protect medical marijuana users from being fired by their employers for marijuana use, effectively being impaired at work. Again, but this is a case of Ross versus Raging Wire, decided some time ago, and before a lot of developments of the type that we've been talking about today, which effectively treat medicinal marijuana like other prescription drugs. This case may have come out differently now. It may have come out very differently in other states. I know there's a case in Massachusetts called Barbudo, which effectively came out treating medicinal marijuana like any other prescription drug, and effectively telling employers, look, this is so commonplace now, it has legitimate medical uses. You employers should handle requests for accommodations effectively for medicinal marijuana, just the way you would handle an accommodation for taking Vicodin or taking some other kind of prescription drug that a medical advisor recommends for a client that may have impacts on how they do their job. And over the years, when these things have come up with clients, I've encouraged them, at least when it's medicinal. Recreational is a whole other thing, but if they have some legitimate medicinal use for it, I've encouraged clients to treat it very similarly to an accommodation request under the ADA or whatever your state disability laws provide. Next slide. So the new thing, AB 2188, which was signed by Governor Newsom last year, but not made effective until January 1. So you still have some time to kind of get ready for this. It goes along the same kind of thinking and the same kind of protocols that you see in New Jersey and in a few other states. It makes it unlawful for an employer to terminate or discriminate in hiring, termination, et cetera, or penalize someone based on their use of cannabis off the job and away from the workplace. That's the language in the law. But goes on to say, and I think this is the important piece, goes on to say, or upon an employer-required drug test that has found the person to have what they call non-psychoactive cannabis metabolites. You know, you want to abbreviate that, that's NPM. We'll explain what that is. During a urine test or a hair test or other kind of bodily fluid test in a drug screening environment. There are exceptions, complete exceptions from the law. Employees in so-called building and construction trades, I don't know that the regulations have defined that, but that's a broad exception. And applicants or employees in positions requiring federal background investigation clearance by the Department of Defense or other equivalent regulations. So DOT, those of you who employ truck drivers that might be regulated by the Department of Transportation would be exempt from this particular law. You know, other kinds of professions, pilots, bus drivers, truck drivers, other people that might be regulated or need security clearances in agencies like Homeland Security, Department of Energy, FBI, those types of jobs would be exempt from this particular job, or even a state law. So think of a university If the university is receiving federal funding or federal licensing related benefits or entering into a federal contract, you too could also be exempt, at least from the requirements of AB 2188. But again, offsite use, off-duty use, and then the question about the NPM, the non-psychoactive cannabis metabolites. So because it addresses this, this is one of those situations where you read the law, it puts this into place, it has these definitions, but it doesn't really tell you much about what they're talking about. They're sort of leaving it to regulations and experience to flesh this out. Effectively, what it's saying is that your tests, if they screen for these so-called non-psychoactive cannabis metabolites, which I guess are chemicals which are not which do not indicate sort of current psychoactive impairment, then, and that's the reason you're excluding somebody or terminating somebody or not hiring somebody, then you're going to have a problem. So the question is, if you can't screen out for that, what can you test for? Our recommendation is always going to be, ask your drug test provider if you have one, if their urine or drug test screens are screening out for what they call non-psychoactive cannabis metabolites. Some employers, some of our clients, in looking at kind of the options coming up, have concluded, depending on the industry, we're not going to test for this anymore. It is just too much trouble. It's too complicated, and then they've taken THC, any type of cannabis, off the drug screen panel. That's okay, and that's appropriate in your industry. If you're in a safety sensitive industry, or for some other reason you have to continue testing because you're required by federal law, et cetera, that may not be an option. What we've seen in kind of the discussion among lawyers, among medical professionals, and sort of the drug testing industry, is that rapid saliva testing, so not used particularly frequently in the kind of the research that we've done. Most employers still tend to use urine testing, but rapid saliva-based testing could be a solution for this problem because it has a shorter window of detection, as it's been explained to me. It's easier to administer. It's non-invasive. It's not sort of as invasive as urine, and it could provide this quote fairness to legal users outside of work. So in other words, if you use a typical urine test, and your provider is telling you, well, that urine test could indicate these non-psychoactive metabolites going back as far as a week, 2 weeks, even a few days before the testing, that could and probably would violate the new AB 2188 standards, whereas possibly a saliva-based testing could show much closer and much more recent use. It could focus in on active psychoactive cannabis metabolites and allow you to sort of be in that position where you could take the position that, no, this probably shows that someone is impaired and they violated the test. It's not screening for something that is not currently creating impairment. So I'll pass it along to Ashley to talk about Illinois. Illinois is another one of these states that we may see other states kind of either following or creating similar statutes, depending on what's going on in Illinois.
Thanks so much, Nestor. My name is Ashley Orler. I'm a partner here in Chicago, and I'm also co-chair of our firm's Cannabis and Employee Substance Abuse Practice Group with Kia Denner. I'm going to jump right in, and Kia, if you can move to the next slide, please. Thank you. Illinois is a little interesting because we have a lot of laws that were impacted by the passage of first medical cannabis and then recreational cannabis. Both are legal here in Illinois as of right now. But we have other employment-related laws that were impacted by the passage of both of those laws. In Illinois, we have a law called the Illinois Right to Privacy in the Workplace Act. It was passed in 2008. Really, the goal of this law is to try to protect employees' private legal action or conduct outside of the workplace and to protect it from the employer discriminating, taking some sort of adverse action against the employee as a result of that. What's interesting about the language of this law is it states that as otherwise specifically provided by some other law, and before 2020, the language here on the slide in bold that provides for a reference to Section 10-50 of the Cannabis Regulation and Tax Act, that language was not in there until 2020. So the law as it existed used to read, just except as otherwise specifically provided by law, it shall be unlawful for an employer to refuse to hire or discharge an individual because the individual uses a legal substance or a lawful product basically outside of work, right? And a lawful product is defined very, very broadly as any product legal under state law. So we had a bit of confusion and frustration as an employer here in Illinois when medical marijuana was passed. And Kia, if you can move to the next slide, please. That occurred in 2015. So we passed medical marijuana here in Illinois in 2015 under the Compassionate Use of Medical Cannabis Pilot Program Act. And it provides for the legal use of marijuana by medical patients. And it has similar protections against discrimination as the New Jersey law, which Kia has already gone through. When that occurred in 2015, we as employers were really struggling with what to do with our drug testing of employees who might legally be using medical marijuana outside of the workplace because they'll test positive for THC, but that doesn't necessarily mean that they were impaired on the job. So we've been dealing with this issue for quite some time here in Illinois. Luckily, our legislature understood that issue. And in 2020, when the recreational legalization of marijuana law took effect here in Illinois, the legislature addressed some of this. So it added that bold language in the Illinois Right to Privacy in the Workplace Act, which very much helped employers clarify that, oh, okay, we can still enforce our drug testing and zero tolerance policies if we have those at the workplace. So that was super helpful. The Illinois Cannabis Regulation and Tax Act, which allows for legalized recreational or adult use marijuana here in Illinois, it also contained a number of really helpful provisions related to employment. So for example, it specifically states that zero tolerance and drug-free workplace policies are allowed. It allows for drug testing of cannabis and allowing employers to prohibit being under the influence of cannabis at work. And it also defines an impairment, which is really helpful. And I'm going to quote from the act really quickly. Impairment is defined as an employer can consider the employee impaired or under the influence of cannabis if the employer has a good faith basis that an employee manifests specific articulable symptoms while working that decrease or lessen the employee's performance of the duties or tasks of the employee's job position. Okay, that's a mouthful, right? So it has a definition. What does that mean practically? Kia, let's move to the next slide. So how do we navigate all of this? And how do we as employers now take the burden on our own shoulders to determine whether our employees are impaired while working for us. Of course, our policies as businesses are super important here. A lot of companies still have drug or alcohol testing policies, which are fine, even in states like Illinois. We want to make sure that our policies are really specific about what those drug testing circumstances entail. We have obviously our post-offer, but pre-employment drug testing. A lot of clients I've worked with, especially here in Illinois, have decided, especially if they don't have employees working in safety sensitive or security sensitive positions, they've decided not to screen for marijuana in terms of a pre-employment screening. They've just taken it out. They don't want to mess with it, so to speak. And for their business, if they're able to do that, that might be a perfectly great solution. Also, we're seeing policies for reasonable suspicion testing, post-accident, of course. And then if we do have those certain positions where we want to make sure folks are not impaired in safety sensitive or security sensitive positions, we can do random or periodic testing. Of course, I think everyone has heard over and over today that drug testing in and of itself, though, is not necessarily determinative that your employee is impaired on the job by cannabis. Let's move to the next slide, please. So, identifying impairment is going to be key when we're dealing with a workforce in any of these states where marijuana is legalized. Frankly, we're seeing this trend. New Jersey and California are kind of forerunners, but we expect this trend to continue, especially in states where, generally speaking, we're seeing a lot of employee protections generally with their laws. We're going to see, we believe, a lot more states following this trend going forward. So a drug test in and of itself is not going to be sufficient, right? So this impairment is key, identifying impairment. So this is kind of a step-by-step process that we've come up with in terms of providing guidance to employers on how to determine impairment. So first and foremost, this usually comes up with some sort of complaint. We have an employee come forward, maybe it's a manager, about another employee. Just the other day, I dealt with a coworker who, not my coworker, a client's employee, let's be clear, who smelled marijuana on another employee and was complaining to management about that smell. So what do we do when we have that complaint? Well, it's really, really important to try to get an observation firsthand and immediately by somebody in a position who's been trained to look into these matters. And then, you know, we have to be careful too. It's not just gossip or kind of certain employees wanting to get another employee in trouble. And so it's really important to try to get somebody who's been trained, who has managerial authority, to start looking into this. After the complaint and the observation, which I'm going to talk about a little bit more in a moment, we want to remove the employee if they're working in a safety or secure sensitive area, right? And especially if we believe that something that employee is doing might cause or create a safety issue for others. Then we want to, and this is incredibly important, document the observations and document the complaint. I'm going to talk a little bit more about that in a moment. In terms of assessing the situation, once the observation has been completed, it's really important for those who observed with managerial authority, maybe it's a member of HR, to kind of gather up and assess the information. Typical questions to ask during that assessment process are really similar to other investigations that we do internally. We look at whether it's reliable, the complaint that came in, who witnessed the observations or the behavior of the employee that we believe may be impaired. Is our documentation good? And importantly, if there's a disagreement about whether we have a good faith belief that somebody's impaired, we might need to consider bringing in a third party to analyze all of this information to determine whether we should take additional steps. It's important then, if we believe that the employee is impaired, or we have a reasonable belief the employee is impaired, to meet with the employee. Again, we're assuming here in this scenario that the employee is not a union employee. There's some different rules that would then take effect in that scenario. We want a member of HR and a member of management to meet with the employee. We want them to clearly explain the observations and documentation of what's going on. And we want to absolutely point to our company policy for what we're doing and what we're going to do next. Again, explain to the employee that pursuant to our policy, we're sending the employee for drug testing. And when we send the employee for testing, please, please, please do not have them drive themselves, right? If we believe they might be impaired on the job, we do not want them driving to the drug testing location. Okay, observations. So we want, obviously, the observations to take effect in real time, ideally, immediately when that complaint or accident occurs. And we want to try to get somebody else involved, right? Ideally, we have maybe 2 managers who are going over to the employee, trying to observe them doing the work, see what's going on. It's probably a good idea for one of those managers, at least one of those managers, to talk to the employee, get up close, see if they smell. Are their eyes dilated? Are they wearing sunglasses? Speech slurred? Is their coordination or movements kind of off? It's not just one thing, right? And I hear often where there's a smell of marijuana. Unfortunately, I think that smell can linger on clothing that hasn't been washed. If somebody smoked maybe last night or over the weekend, that smell can kind of stick to them, frankly. So you want to kind of try to encourage your members of management to really observe other characteristics, both in behavior and physical characteristics. Next slide, Kia. Documentation, as I mentioned, is essential. As an employment attorney, I say this on a daily basis, multiple times a day to my clients: document, document, document. We want to document the complaint, document the observations, be as specific as possible. Ideally, we love emails because there's a date and time stamp. We know who sent the email, who received the email. It's great. If it's not in writing, there's an argument, it didn't happen. And then finally, we want to make sure training is going to be huge here. We've got to train, as Kia mentioned, right? We've got our wire experts at some point in the future. We want to train our managers and supervisors on our policies, on how to make these observations, on how to document things. We want to make sure we do refreshing training so that they don't forget this. And then finally, this area is changing so rapidly that we need to review our policies, our training guidelines, and our practices regularly. We all want to make sure there's enough time for questions. So I'm going to end there.
Okay. Thank you, Ashley. And we have our SHRM codes here and our HRCI code. So I'm going to leave this up for a few minutes so that anyone who needs it can copy that down. I also want to just kind of sum us up, take the last couple minutes that we have and just kind of try to synthesize this for everybody, because I recognize that there was a lot of information that we just threw at everybody. And, you know, certain companies may be, you know, really up to speed on some of these issues, others maybe not so much. And of course, we spoke a lot today in generalities. So, you know, there may be specific, and I've seen in the comments and in the chat, there's a lot of specific questions. And of course, if you have specific questions for us, you can always shoot us an email and we'll be happy to answer those questions for you. But I think I could try to synthesize this down pretty quickly for you. Number one, you need to check the law in the state that you're operating in. I hope that should be clear, right? We talked about 3 states in particular today, but you know, as we said in the very beginning, there are many states that have these types of of laws, and there's at least 19 that have employment protections for medical marijuana users. So you need to know where you're operating. You need to figure out, what are the ground rules for where you are. If you're a DOT, if you employ truck drivers and you have a lot of people with CDLs and you're going to be following DOT Part 40, you're going to basically follow DOT Part 40. I did want to mention that because there were some questions around that, and most, if not all, of the state statutes that have these employment protections, they will have these federal carve-outs, and they will specifically apply to those situations. So DOT Part 40, you're still going to follow DOT Part 40. And if DOT Part 40 requires you to drug test somebody in a specific circumstance, you're going to go ahead and do that. And then if the law and the regulations require you to pull that person off the road, you're going to go ahead and do that, even if you're in a state like New Jersey or New York or Illinois that maybe has these protections. So you're going to go ahead and you're going to do that. But I also want to just kind of, again, sum us up by noting what Ashley talked about at the end is really, really important. You need to have policies in place. If you don't have policies in place, you should think about getting your policies in order. You should do state supplements when they're required to do. Doing a one-size-fits-all drug policy, if you operate in 23 different states, is probably not the best approach for you at the moment, unless and until the federal law changes and we have a more homogenized approach to this. So have your policies in place. Think about providing these types of training to managers so that they can understand what they're doing. Can you just go ahead and send somebody for a drug test and then fire them? Well, I hope that after today, at least with respect to that question, you at least know, well, wait a second, maybe I should stop and think and at least check what jurisdiction I'm in before I go ahead and do that. There's going to be plenty of states where you can still do that, but there's going to be plenty of states now where you can no longer just do that. And so the answer is going to be, as Ashley just took us through in the last 15 minutes or so, you really want to have that documentation of the observations down. And that's where New Jersey and California are heading. And as Nestor also said, if you're in a blue state, this is the trend. Okay, this is the trend. Even if your medical marijuana statute doesn't have this yet, you can bet that plaintiffs' attorneys across the country are going to start to pick up and repeat and parrot these arguments over and over again. And they're going to say things like the drug test does not indicate that my client was impaired, and therefore you fired them in violation of public policy, or you fired them because of their disability, or you fired them because they complained about something, so it's a whistleblower complaint, or you fired them in violation of the medical marijuana statute or the adult use statute. So there's a lot of options for plaintiffs out there right now if you don't pay attention to this and come up with a strategy and a plan for dealing with it. So with that said, there's way too many questions in the chat for us to go through, and we're already a little bit over time. So again, what I would say is please feel free to reach out to us. We will be providing copies of the PowerPoint and perhaps other resources to you as well. So just please reach out to us and we can answer any individual questions you have as well. And with that, I'd like to thank everybody, and thank you to Ashley and thank you to Nestor for taking their time today. And thank you all very much for attending.
Thank you for joining us. We'll now end the webinar.